Dube, thanks so much for joining us. Welcome to the program. So for viewers at home watching this, we've watched court stories before and witnesses get asked questions and then the lawyers follow up with some of those answers. This doesn't seem to be sitting well with the former president and his legal representatives. Why is that? Please try and walk us through the tensions that have been raised and if they're justified.
Good afternoon and thank you for having me. Well, I think it's quite important that you preface this question with reference to the courts, because it's important to understand that there's a difference between courts and how the courts conduct themselves and the manner in which a commission of inquiry, such as the Zondo Commission, conducts itself. So the manner in which their rules governing their processes are quite different, and but that said, there are some instances where the procedure that's followed in the courts is the same as the procedure that's followed within a commission of inquiry. So at the moment, the debate is the extent to which the leaders of evidence can be allowed to cross-examine implicated individuals. But I think a closer reading of the rules and regulations which govern this particular commission of inquiry would imply that the leader of evidence is well within his rights in cross-examining former President Jacob Zuma.
All right, so again, you know, we as lay people quite confused, because I would imagine that the job of the commission is to try and assess that which was said by witnesses that implicated President Zuma, and he will give his version and they need to get clarity on what he's saying. Is that cross-examining? Where does it jump the line from getting clarity to cross-examination that could be seen to be something in a criminal court as opposed to the inquisitorial nature of an inquiry?
Well, you're right in establishing the fact that the Commission of Inquiry is really out to establish the facts. And obviously, in establishing the facts, there will be instances in which implicated individuals are going to be cross-examined. And I think in this regard, if we consider certain rules that govern the Commission of Inquiry, and here I'm going to be quite specific and go into the rules. So Rule 3.2 of the Commission, for example, which talks about how the evidence leader can question implicated individuals. It actually states that the evidence leader may ask leading questions, and these leading questions can be interpreted to be a form of cross-examination. And not just that, but then if we also consider another rule, specifically Rule 6, Rule 6 gives the chairperson of the commission a wide discretion regarding the rules of evidence. So it essentially says that if the chairperson is of the view that it's reasonable in that particular instance to allow cross-examination, then the evidence leader can go ahead with cross-examination. So in a nutshell, there's really nothing in the rules that prevents the leader of the evidence from cross-examining implicated individuals. Although, of course, it is important to note that this isn't a court of law, and this is really a commission of inquiry, which is really about establishing certain facts.
All right, so the other issue that keeps coming up is that he's not being treated in the same way as other witnesses. Is there anything in the rules that say that what witness A must be treated as witness 2? Their nature of appearance is different. One is an implicated person, another isn't. So by their nature, surely they can't be addressed in the same way.
That's true, but I think we also need to consider some of the rules and regulations that guide the functioning of the Commission of Inquiry. And in that sense, I think there is a certain degree of protection which is afforded implicated individuals. So, for example, there's a specific regulation which says that if this individual discloses certain facts, which are harmful to them or certain facts which would implicate them in certain wrongdoing or certain criminal offenses. If they self-incriminate, then law enforcement agencies cannot use that evidence in a subsequent criminal matter. So that means that they are protected. And secondly, before such implicated individuals are asked to appear before the commission, they've been given a notice. And in terms of that notice, they're given the instances in which testimonies from various witnesses has implicated them. So in that sense, they are given a room to present their case and defend themselves from those allegations that have been raised. So in that regard, there is a measure of protection which is afforded to such individuals, and it's not entirely true that they are being treated differently. If anything, there's a measure of protection that's granted to them.
All right, and perhaps in conclusion, the legal representative of one of the legal representatives of former President Zuma suggested that they would not participate in this process if it didn't go according to what they felt was fair. And I'm wondering, can you choose to come or not come? Or, you know, if they get subpoenaed, must they appear? Is this a kind of process where you can choose to appear or not if you don't feel like it?
Well, it certainly is a startling statement to make, because this is a legally instituted body and these are officers of the law, so they can't opt out of certain proceedings of the body, and the commission has extensive powers. So if a subpoena has been issued by the court, then they're obliged to follow, to abide by that particular subpoena. So I think in that regard, it is a rather surprising statement to make, and we also need to bear in mind the fact that this commission does have extensive powers in terms of dealing with individuals who, for whatever reason, refuse to cooperate with the functioning of the commission.
And once you're on the stand, you're not allowed to refuse to answer a question.
Indeed, you're not allowed to refuse to answer a particular question, but that said, and if you do implicate yourself, law enforcement agencies cannot use that against you. So in that sense, there's a measure of protection against self-incrimination, and it's really geared to ensure that witnesses are able to share as truthfully as possible their version of certain facts.
All right, constitutional law expert Dube, thanks very much indeed for your insights on what we've been seeing during the course of the day taking place at the State Capture Commission of Inquiry. All right, we'll have more on that and other issues coming up after this break. Stay with us.